And we are broadcast. Hi, welcome everyone to our afternoon webinar today titled Ask Your Attorneys. My name is Karen and I'm a paralegal here at the Estate Planning and Elder Law Center of Brevard. Today our attorneys will be providing you with an overview of estate planning and long-term care planning. We encourage you to use the chat feature to ask our attorneys questions, and we'll be asking you a few questions as we go along. While you're not required to ask or answer any questions, we do encourage your participation. I would now like to introduce our attorneys who will be providing the presentation today. Robin Peterson is a certified elder law attorney by the American Bar Association. He's been practicing in Brevard County since 1990, and he's a former Air Force JAG officer. Cassidy Peterson is an attorney with her concentration in elder law from Stetson University College of Law and her Master of Business Administration from Stetson University. And Roger Klafka is an attorney with his concentration in elder law from Stetson University College of Law, and he's an Air Force veteran with over 25 years of military service. And now I'm going to turn things over to our attorneys for today's presentation.
Good afternoon, everybody. My name's Robin Peterson, Cassidy Peterson, and Roger Klafka. We forgot to raise our hands when we were being introduced. This, as you can tell by the screen, this is the area of law that we practice in exclusively: estate planning, elder law, and paying for financing long-term care costs. We actually have a question that's already been sent in about one version of long-term care, and we'll get to that when we get to that section. We've had over 1,500 estate administrations, either in a supportive role as attorney for the personal representative or successor trustee, or I've actually done a number of estates myself as trustee or personal representative. I've been here for 25 years, but we'll be here a lot longer because they're younger than me. And we have offices, you can see by the screen, see by the map on the screen. We have an office, our main office where we're sitting now in Indy Atlantic, and then in Beer. I encourage you to ask questions as we go. We have three different sections, really. It's state administration after death, how to make medical and financial decisions during incapacity, and then how to pay for long-term care. So feel free. We've got a few emailed questions, but we're happy to have Karen interrupt us, and we'll answer your questions as you send them in. And at the end, if you want us to review documents, we can do that at no charge for you. And just mention you're a participant in this webinar. So this disclaimer we're required to give you by the Florida Bar. It's not legal advice, it's just theoretical advice. It's not pertaining to any one particular situation, and so therefore it doesn't create an attorney-client privilege relationship. And that's all I got to do with Florida Bar.
So this next section I'll go through, and before I go through it, we have a poll. We have a few polls as we go through this, and we'll launch this first one. And if you can answer it, then we'll come back to it with the results. So there's 4 ways that property passes at death. So first is joint ownership. So many people are familiar with owning, say, a bank account with a husband or wife, or property that you own jointly. And at the first death, the property passes to the survivor and passes without probate. So that's one way property passes. A second way that avoids probate is beneficiary designations. So think of, again, a bank account, an IRA, a financial account that you have. And if you have named beneficiaries, then at death, it passes from the financial institution to the named individuals that you have as beneficiaries. A third way property passes is by will. And it's important to recognize that a will does not avoid probate, but a will really is an instruction to the court that says, Here's who I want in charge of my estate. In Florida, that's a personal representative. In other states, it's called an executor. So the will says, this is who I want in charge of my estate. They collect my assets, they pay my debts, and then they distribute to the beneficiaries named in my will. But a will really is the mechanism that goes through the probate process. And then there's trusts. So a trust is, I think of a trust as a bucket that I can put financial assets in, I can put my house in. You are the trustee during your lifetime. And then during mental incapacity, physical incapacity, death, you name who is the successor trustee. The successor trustee is then responsible for the items, the assets in that trust. They collect those assets, pay the debts, and distribute per the terms that you've identified in your trust to your beneficiaries. So it does that, it avoids probate. So those are the 4 ways to pass property at death. And I think we should have the results from our poll.
Karen?
Yes.
Do we have the results from our poll?
We do. They are coming. Yes, we do. They are coming.
Oh, it's 50-50.
Yeah. Okay. So
50% have a will or trust and 50% don't. All right, so I'm going to go over just some common areas of questions that we get. Should I have a will or should I have a trust? What do you mean that my will doesn't avoid probate? Roger kind of touched on that a little bit. Can I avoid probate? Should I avoid probate? But in order to get to all of that, I guess we need to talk about what is probate. Probate's the process of getting an asset from an individual's name once they've passed away into the name of their beneficiaries or their heirs. That's either going to be based on the terms of your will, or if you don't have a will, there's what's called intestate statutes. All 50 states have intestate statutes. They may vary in the terms, but there is something in place saying what family members would get your estate if you were to pass away without a will. A probate process is typically supervised by a court. It certainly is in Florida. And the person that is in charge, your personal representative, will be responsible for filing all the paperwork with the courthouse, finding and collecting any of the assets that were in your name when you passed away, paying any valid creditor claims or debts, and then distributing the remaining assets to your beneficiaries. A lot of people want to know, should they avoid probate? Usually the answer is yes. It's very costly and time consuming. In Florida, I would say the average probate is open about a year and a half. And if you don't have a will, it might not be consistent with your wishes of who you'd want to get your stuff. And lastly, it's public. So probate proceedings are all filed in the courthouse. A lot of people, if you value your privacy, that's not the ideal way that you'd want to pass your assets to your beneficiaries.
I have a question here that's come in. This question says, is it true that the state will get my property if I don't have a will?
No, that's not true. The intestate statutes, it goes in an order of, I guess, who someone would typically want their stuff to go to. Usually the order, and this is not a one-size-fits-all question, but spouse first, then kids, then parents, and then siblings. And then
nieces and nephews, and then cousins.
Okay, so there's like a state says what the order is if you pass away without a will, but it does not go to the state.
And I have one more question before we move on. This question is, do I need to list my cars or boats in my will?
I'll let you take that. You.
Okay. No, you do not. Short answer. As long as your will is drafted properly, that says everything goes to the following people, and that's called the residuary clause. Sometimes it's a good idea to specifically talk about who gets an automobile, so you don't, unless you're just going to sell it, so you're not arguing over who gets it or who has to take it. So, but it doesn't have to be specifically listed.
So some other common questions that tend to come up are, what is guardianship and how can I avoid it? Who will make decisions for me if I'm no longer able to? How will I pay for my long-term care? And are there government benefits to pay my long-term care that I don't know about? I don't know about this particular one, but if we go to the next slide, and we'll go through these areas as we go through these next slides. So your health fails, it's never expected. And I think right now is a time in history that we see that, up close and personal with coronavirus, that you never know what's coming and you never know what to expect or when things are going to happen or when things are going to change. And I think this emphasizes the importance of planning and always being prepared because we don't know what's next.
We've actually had two clients pass away from COVID recently.
And before I go through this next section, Karen, if there's a poll you can launch. So this poll questions whether you have advanced directives, whether you have a power of attorney, healthcare surrogate, or both. So as you go through and answer those and Karen gathers the data, I'll go through the slides. So there's 3 documents that everyone should have, and everyone, particularly over age 18. Once you're 18, you are an adult. You're acting now on your own, and it's not just because you live at home or your parents are there or you're taking care of somebody who's 20 or 21 or 22. They are an adult, and it's important to have advanced directives in place as well as your estate planning. So we'll specifically talk about a durable power of attorney. The durable power of attorney, think finances, and it's who can make financial decisions for me if I can't. So I'm alive, but either mental or physical incapacity. Who can make decisions for me financially? Then there's a healthcare power of attorney. Healthcare power of attorney, you'll name your healthcare surrogate who can act for you and make healthcare decisions when you can't. And also a HIPAA release. HIPAA is the Medical Privacy Act. Your medical records are private and they're covered under Privacy Act rules. But in order for someone to make healthcare decisions for you, they need access to medical information. So that HIPAA release gives someone the ability to access your medical information. Also, if they're doing financial transactions for medical reasons, they may need access to your medical information under HIPAA. And finally, if you have those documents, questions to ask are they current? When were they prepared? The durable power of attorney in Florida, the law changed in October of 2011. So it's important that it's current and meets Florida law. If you do have them, were they prepared by an elder law attorney? I'll tell you, elder law attorneys, we think different. We think about things like long-term care and aging and the needs you may have. So we include elder law concepts into all our documents. And again, do your documents include HIPAA language, because that's incredibly important these days. And Karen, if you have the results from our poll.
I do. It looks like 50% have both. We've got one that only has a power of attorney for finances, and someone doesn't have either one.
And I think those are some of the most important documents you can have, because they're valid during your lifetime, they end at death, but it's something as we go through and talk about them to think through the impact of not having them.
Okay, so if you've planned ahead, then great. You have a power of attorney for your healthcare decisions, your healthcare surrogate. If you haven't planned ahead, we might have to worry about a guardianship. And same thing for finances. If you've planned ahead, then great. You have a power of attorney for your financial decisions. But if you haven't planned ahead, guardianship. So I'm about to talk about guardianship, but before we do that, we have our last poll. Karen, if you could launch that. The question is if you've ever had to deal with guardianship. So while you answer that, I will talk a little bit about guardianships. So guardianships a lot of times happen because someone has not created a power of attorney or healthcare surrogate, And the classic case that we always see is Alzheimer's or dementia, but of course, anything could happen. But let's say someone doesn't have those documents and they're unable to make their own healthcare and financial decisions. Their loved ones have to go to court to get them determined to be incapacitated and get the authority to make those decisions. It's a very time-consuming process. It's expensive. It usually is going to last your whole lifetime unless you regain capacity during your life. It is public record. It is filed with the courthouse, and it's really hard for family members, especially because you haven't at that point named who you'd want to make those decisions. So you might have family members fighting over who gets to make those decisions for you. And after guardianship is, once you've been determined to be incapacitated and you have a guardian, the court has a lot of control over what money can be spent where. And at the end of the day, the court might not appoint who you would have decided to make those decisions for you. Karen, if you want to show us the results of that poll.
We've got 3/4 have not had to deal with guardianship, and looks like one person has.
Same exact results as last week's seminar. So I'm going to talk about how to pay for long-term care and deal with this question. Let me deal with that in a couple slides.
I do have a couple questions before you get into that.
Okay.
This one says, if I have a healthcare surrogate and power of attorney, will that ensure that I won't have a guardianship in the future?
Most times. 95% of the time. The only time that if it's a valid power of attorney and a valid healthcare surrogate designation, sometimes known as a healthcare power of attorney with proper HIPAA language. HIPAA is the Health Insurance Portability and Privacy Act. It's the form that the doctors are very cognizant of. They are not a form, it's a concept of privacy, because if they don't respect the HIPAA law, they can lose their insurance reimbursement, especially Medicare reimbursement, which is a large part of their income. So they take it seriously. So if the two documents I mentioned are in place, you're probably going to avoid guardian. The person that signed the documents is probably going to avoid guardianship. The only time we really need a guardianship, the court supervised activity of handling the affairs of that incapacitated person, is really if they're being exploited, or they're just neglecting their needs and not being compliant with what a healthcare provider would find to be important. So yes, they work very well to avoid guardianship, usually.
All right, and this next question says, who pays for the guardianship if it's necessary?
Want to do that one? You have another question?
So in a guardianship process, the person that's coming forward to bring a guardianship case would come to see an attorney, and they are going to pay the initial fees for that. And then the court will appoint an attorney to represent what's the alleged incapacitated person. So that the court will appoint an attorney for that person, and they are also entitled to fees for that. Then it's a question of, at the end, who ends up paying for that. If it's valid and the guardianship moves forward, then that ward, the alleged incapacitated person, if they are shown to be incapacitated, then that person's finances will be used to pay those fees for the attorneys as well as the medical examining committee.
If they have them.
Yeah, if they're not in it.
Yes.
Yeah. Otherwise, the family in the state of Florida pays for the examination. The state of Florida will, in an indigent guardianship case, they will pay the exam committee fees, and they will pay the attorney for the alleged incapacitated person. But the family will end up carrying several $1,000s of the fees. if the ward is, has no money. Okay, so what is long-term care? These are called what you're seeing on the screen. These are called activities of daily living, transferring meaning walking, dressing, bathing, feeding, toileting, and usually it includes a definition of incontinence. Not always though, that's the wild card, because if a person is incontinent and they can handle it themselves, it's not considered an activity of daily living that needs assistance. So where do people receive long-term care? I would say most people receive it in the home, be it family members, friends, or a paid professional. Adult daycare, usually just while the other family members working from 9 to 5, or 8 to 5, they'll be at an adult daycare. Independent living community is a very common one. And then the next step up on the rung would be assisted living facility. More activities of daily living would need to be assisted with. And then top rung is a skilled nursing facility or a nursing home. Not everyone wants to go. Well, in fact, very few people want to live in a nursing home, especially if you've ever been in one. But choosing between that or the alternative is a lot of people end up in a nursing home. And nursing homes are expensive. They're, at least in this county, at least $10,000 a month. So thinking about paying for them is important. And the next slide will go through ways of paying for the long-term care. But I wanted to, this is a good question actually. And the gentleman that asked us is watching today. He says, does it make sense to move to a continuous care retirement community? CCRC is what they're known. And he describes what his thought process, and I thought it was a really good summary of what a CCRC is. The entry fees can be $250,000 to $350,000, depending on the amenities and the individual CCRC. And his specific focus is he wants to know if the attorneys think it's a good way to safeguard your future as an option to long-term care. You pay a monthly fee, usually for a couple, usually about $4,500 to $5,000 a month. It includes all your meals and transportation and shopping and entertainment. But if there needs to be placement in a nursing home, that can, if you're paying out of pocket, that's, like we said, $10,000, an additional $5,000 a month at least. And with the CCRC, they kind of self-insure, so to speak, so that you're only paying an extra about $1,000 a month. So is it a good idea? Really, I kind of think of a CCRC as, and I think there's only one in the south end of the county, and it's in West Melbourne.
There's only one in Brevard County.
Oh, they're the only one? Yeah. And that one has gotten mixed reviews over the years. I've heard really good and really bad. But that's true for any kind of assisted living or nursing home. It really depends on who the manager is at the time, what kind of staff they have. But I think of a CCRC as a way of controlling your costs. So if you want to pass your assets onto your heirs without digging in real deep to possibly digging in real deep to your assets, a CCRC can make sense. It's a substitute for long-term care insurance, or a substitute for the unknown. It's a way of planning. So for $300,000, you're going to safeguard your estate for your kids, versus paying $5,000 a month, or a year rather, on the average or more, for 20 or 30 years for long-term care insurance. And by the time you get to be 65, 70 years old, that long-term care, that traditional long-term care insurance can be way more than I just said per month. So how do people pay for it? There's only 5 ways that I know of. Long-term care insurance, Medicare, VA aid and attendance for wartime vets, private pay, and Medicaid. And there's really no other way. I need to drill down a little deeper than that, but those are the 5 ways of paying for it. Long-term care insurance, there's 2 kinds. There's the traditional long-term care insurance that I was alluding to before. It's kind of like car insurance. It's use it or lose it kind of thing. And then there's a newer kind of, it's called a hybrid policy that financial planners sell. And it's kind of like life insurance. If you don't need it and you don't use that fund of money, then it goes to fund a life insurance policy that'll pay to your heirs. So it's not use it or lose it. And so that's another way that you can possibly, the gentleman that sent us this email could possibly think about, not parting with $300,000 right now, buy one of those newer hybrid kind of long-term care insurance policies. Those are a good deal. They make a lot of sense. And you don't even have to be insurable for life insurance. There's another way of going at it. It's instead of using life insurance, same kind of concept, but it uses an annuity instead. And then there's Medicare. And as the screen says, Medicare only pays for up to 100 days of skilled nursing care during rehabilitation. So rehabilitation means you have to be improving. Once the person plateaus or where they're not going to improve anymore, Medicare will stop paying. When I started doing this in the early 90s, Medicare frequently would pay for rehab after 3 days in a hospital, would pay for rehab for 100 days. But they've gotten very cost conscious, and now I'm seeing 20, 25, 30 days only. So can't say Medicare, you can't rely on Medicare. I mean, we do seminars on this. We could go into more detail, but Medicare is not a good place to plan on receiving assets to pay for your long-term care. Then if you were a wartime vet and you did it at active duty service, then you can receive VA aid and attendance. And that's a needs-based program, and it pays for ALFs, pays for skilled nursing facilities, pays for home health care, pays for prescriptions. So it's a good benefit. I know both my parents were, my dad retired Air Force, but my mom and dad were both in World War II, and they both qualified for it. So it was a good benefit for them. That's where I learned about aid and attendance too. And then private pay, that's very intuitive, but that's very expensive as well. And when you think of, say, $10,000 a month or $5,000 a month for ALF, assisted living facilities, or 10 for a nursing home, remember, it's not 10 coming out of your savings. It's the difference between your income and the excess that goes to the skilled nursing facility. So it doesn't tend to dwindle as quickly as you might think, just looking at the $10,000 a month figure. And then Medicaid, that's also a needs-based program that pays for skilled nursing facilities. They have a assisted living facility program, but it doesn't pay much. And the wait list is 2 years, 3 years now. It varies, but it's no less than, I haven't seen it less than 2 years in a long time. They don't fund it very well. They fund the skilled nursing facility program much better. All right.
All right. So I have questions here that have come in through email and through online. So the first one I'm going to ask is, how do I know, or how will my family know, which facilities are good and which ones are bad?
Okay. There's the Agency for Healthcare Administration is the government agency that regulates all of the facilities. You can go to their website and look at facilities in your county, and they will have a rating for the facilities, both for their care and their, I'll say, administrative business office, and it'll show if they've been fined in the past for anything.
They rate them 1 to 5 star, and there's a few facilities in town that have been 5-star for a long time. And then there's one in particular that kind of fell off from 5-star to 2 or 3 star on the average, because it really depends on the the management. that come and go.
Okay. The next question says, what if my income is too high to qualify for Medicaid? How can I make sure I don't go broke while trying to pay for long-term care?
Well, if your income's too high for Medicaid, you can do I won't go down too many legal rabbit holes, but there is what's called an income trust, where you put in the excess income between what's allowed and what is you have that's over, that flows through what's called an income trust. So just because your income's too high for Medicaid, that's not, talk to an attorney, talk to an elder law attorney about how to still qualify for Medicaid.
Okay. I have a few more. The next one says, can I just add my daughter to my bank account and house to avoid probate?
Roger?
Yeah, I'll tell you that. It's a common question. There's a danger in that. So adding someone to, I'll say two different areas, a financial account. Now they are an owner. So if they get in debt, you've opened up that asset now to their debt, or if there's a lawsuit against them, or if they get divorced or in their death. Now you've added all these other concerns of their life onto your asset. And then for a house, I would say particularly with a house, you're also giving up a tax advantage, and I won't go too deep into this, but step-up basis. So if you die and you leave that house to someone, they inherit it at your date of death value. But if you added them on there, now they can inherit it. Potentially you're avoiding probate, but you're missing out on a huge tax advantage through step-up basis. So I think a better avenue is, especially with real estate, is looking at a trust, because with a trust, now you have the advantage of holding real estate in Florida if you have it, or multiple states if you have it. And you can also identify terms and how you want to pass that property, and you avoid all those negative issues that come by just adding somebody to either a financial asset or your house.
And you still can preserve the original homestead exemption. You don't have to start from scratch again when you put your house into a trust.
All right. The next question I have says, if I have kids from a previous marriage, how can I make sure that they receive something when I die rather than everything going to my spouse?
Well, you take that one.
Because blended families are, wow, that's a big question. It's a lot. No wonder you punted on that. Okay, so with blended families, that's the most, one of the most difficult kind of estate plan, or it tends to be one of the most difficult kind of estate planning, and probably the most fun because of all the balancing of the factors. Maybe not fun for the blended family, but fun for the attorney that is wrestling with all the considerations. There are so many ways of attacking that animal. Say it's the wife with kids of the prior marriage, she could do her own trust or have her own separate money that she had prior to the marriage in a bank account or in a trust that goes right to the kids when she dies, automatically by beneficiary designation with the bank account. There's an elective share that the husband, in this case, in this hypothetical, the husband would have. He has the right to 30% of her assets. So prudent planning would have the couple doing a premarital or a postmarital agreement waiving the rights, that 30% elective share right, and the right, and depending on the history of the house, the length of the marriage, the house, the husband in this case would have certain rights to as well if it's a homestead. So that can be an impediment to passing your wealth to whoever you want. And you can have the husband, both spouses, waive the rights to the other's elective share. And I could probably stop at that. That's a smattering of the considerations. But believe me, relations of the kids with, the stepkids is vitally important too. So.
I guess it's safe to say they should probably see an attorney to deal with that.
Yes.
Yeah. Don't do brain surgery yourself. on yourself.
Okay, so I have one more question, the last question. This one says, my daughter thinks she's too young to think about estate planning. What's the ideal age to start thinking about it?
Well, go ahead.
I think one of Roger's slides also mentioned this, that powers of attorney and healthcare surrogates are super important. As soon as anyone turns 18, I can say that I signed mine when I turned 18, because the problem is, as soon as anyone turns 18, no one has the authority, if something happens, to make their healthcare and financial and healthcare decisions for them. The other concern is if your daughter has children of her own, she would probably want to be able to say who would be the guardian of those minor children if she were to pass away while they were still minors. So that's another thing to think about that needs to be addressed in estate planning documents. So as far as ideal ages, I think everyone needs to think about it as soon as they turn 18. And if they don't, then definitely as soon as they have children.
I was wondering why my friends, when Cassie's my daughter, in case you missed it, as soon as she turned 18, I go, well, what happens if something happens to her? Because my friends would come in when their kids turned 18 and do powers of attorney and healthcare surrogates, and it wasn't real for me until it became real. And then all of a sudden I go, yeah, that's it. I've been telling people that for years now.
And that's all the questions we have.
Okay, nothing in the chat box?
We already did those.
Okay. Roger, you haven't talked much.
No.
Talk about this slide.
So if you would, give us feedback, and we're going to email the forms out. So you'll get a form email. If you can get that by email, fill it out. We definitely appreciate the feedback. If you don't want to do it through the form, then through the email you receive from us to get into the seminar today. So we really appreciate your feedback. If you want slides, then we can send the slides to you as well. And also, if you're interested in sitting down with us for an estate planning appointment, there's no cost to do that. We're happy to sit down and talk through one-on-one, so you can actually take your assets, we can posture your estate to where it needs to be. Or if you've already completed estate planning documents, we're happy to bring those in. We'll sit down with you again. There's no cost for that estate planning appointment. We'll go through your current documents and we could see if they're good or if any changes we would recommend.
We prefer face-to-face, but we do have teleconferencing and Zoom that we can do. There's signing options we've got as well if you really don't want to be around us. Okay, I think that's it.
That's it.
Hey, thank you.